I'm ready to introduce our second panel for the afternoon on sectoral solutions on new forms of industry-level regulations. And our speaker is Professor Cynthia Esland of NYU School of Law, and the co-commentators are Jay Chun, Friedman and Anspach, and Zachary Fassman, Fassman ADR, and professor at Michigan Law. Take it away.
Thank you. Thanks, everybody. I'm really happy to be here. Happy to see you all. In many cases, this has been a regular engagement. So I want to start on very familiar ground. The pathologies of barely regulated labor markets and bare-knuckled labor conflict in the early 20th century led to two dominant solutions in the New Deal: the NLRA's model of enterprise-based collective bargaining and the Fair Labor Standard Act's establishment of some national minimum standards. Those were obviously meant to complement each other. The collective bargaining was meant to empower workers in the relatively productive core sectors of the economy to negotiate for higher wages and better working conditions. And the FLSA was meant to set a floor on collective bargaining, but also a floor on the conditions for workers who were not likely to be able to bargain for higher standards for themselves through unionization. So for the mostly white and male workers in those leading sectors of the economy, that two-pronged strategy worked relatively well for several decades. Collectively bargained wages, benefits, protections, raised the bar across much of the economy and contributed to 3 decades of widely shared prosperity. Since then, of course, collective bargaining has shrunk and virtually collapsed in the private sector. So that leaves the vast majority of private sector workers on their own. Some of them have quite a lot of bargaining power, but many don't, and they are relegated to the under-enforced floor on labor standards, on minimum standards. Now that floor, that publicly prescribed floor of minimum standards, has a lot more planks in it, and it's higher, especially in some worker-friendly cities and states, than it was in the New Deal. But any floor that applies across the whole jurisdiction, federal, state, or local, is constrained by what is sustainable or what's thought to be sustainable in the least productive sectors of the economy. So call that the least common denominator problem, and I'll come back to that. The stagnation of terms and conditions of employment and wages for lots of workers and the decline of collective bargaining at the enterprise level, that's led to growing interest in the U.S. in sectoral bargaining. Sectoral bargaining was a top-line recommendation of the final 2021 report of the so-called Clean Slate Project that was operating out of Harvard Law School for several years. And the popularity or the interest in sectoral bargaining stems from the relative success that it has had in many European countries, where sectoral bargaining over basic economic terms aims to take wages out of competition, wages and basic economic protections across whole sectors of the economy. It's kind of the road not taken in the U.S. back in the New Deal, and there's reason to think that it might have fostered more durable and far-reaching institutions of worker representation. It's very hard to get there from here, especially at current levels of union density. But some scholars have been observing what they consider to be glimmers of sectoral bargaining on the ground. So most prominently, Kate Andreas from Uptown, in a Yale Law Journal article called The New Labor Law, not the New Labor Law, blah, 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 just the new labor law. She argues that something akin to sectoral bargaining, something aiming towards sectoral bargaining, may be taking shape out of recent organizing efforts among low-wage workers. A lot of that activity revolves around the Fight for 15, spearheaded by SEIU in the fast food sector. A leading example that Andreas focuses on was the New York State Wage Board that was convened in 2015 by then Governor Cuomo for the fast food industry. And that wage board, which included representatives of workers, employers, and public officials, adopted a $15 an hour minimum wage in the fast food sector to be phased in over several years. It is both sectoral in scope and tripartite in the meaning it has representatives of both sides, both stakeholders as well as the public. Then last year, the California legislature adopted a somewhat similar but quite a lot more ambitious tripartite standard setting structure for its fast food industry. It's going to deal, if it goes into effect, which is going to actually depend on the voters in a November referendum, but it will deal with wages as well as other terms and conditions of employment for the fast food sector. Some proponents and some opponents of the so-called California FAST Act have described it as a form of sectoral bargaining. That's not what it is. And if you came hoping to hear about sectoral bargaining, I'm going to disappoint you a little bit. Those structures, like the New York and California tripartite boards, they might be stepping stones to sectoral bargaining. That remains to be seen. But what they are now, I think, is worth studying and trying to understand for their own sake, because they have some real virtues. So I want to return to the taxonomy that I have kind of sort of sketched here. Yes, sorry, I should have put that up earlier, but the wage boards have their origins back in the New Deal itself, actually, and trace back to some national sector-specific wage boards, and Kate Andreas tells that story really very well. We can locate legal strategies for raising labor standards along two axes. There's a vertical axis that runs from standards set at the level of the whole jurisdiction, whether that's local, state, or national. And that runs up to those set at the enterprise level. And I say up because they have to be higher. They can't be lower. If they are different, they have to be higher than standards set at the whole jurisdiction level. And then there's a horizontal axis that runs between collective bargaining, in which the government provides a framework for bargaining but doesn't dictate anything about substantive results. That's one end of the spectrum that I want to suggest. And at the other is direct government regulation through imposition of mandatory rights and minimum labor standards. So our two prevailing approaches with their origins in the New Deal to improving labor standards in the US are located at the opposite corners of what we can start to envision as a grid of, divided by these axes. So we have collective bargaining at the enterprise level, and then we have minimum standards and mandatory labor rights at the jurisdiction-wide level, national, state, or local. It's pretty hard, actually, to envision either government-imposed standards at the enterprise level, that is something different from what prevails across larger groups, or collective bargaining at the level of the whole jurisdiction. There's just too much diversity among the industries covered. But the range of alternatives expands when we recognize intermediate points along each of those two axes. So sectoral standards are at the midpoint between jurisdiction-wide standards and enterprise-level standards. And then this is going to take a little more explanation, what I'm calling co-regulatory approaches, or sort of hybrid approaches to standard setting. They are at the midpoint between collective bargaining and ordinary conventional regulation. So the New York and California standard setting boards sit smack in the middle of the grid that we've now sketched out here. They set binding standards at the sectoral level, and they do so through a process in which representatives of both workers and employers participate alongside public officials, representatives of the public at large. So what I'm calling, and we'll explain a little bit more about, sectoral co-regulation has some real virtues relative to its alternatives on either side along both axes. So that's what I want to talk about. So I don't mean this to be a replacement in any way of enterprise-level collective bargaining or jurisdiction-wide minimum standards, but as a complement to those structures and as a supplement to those structures, sectoral co-regulation could bolster wages and working conditions for many workers and could amplify workers' voices within labor standard setting and fill part of the gap left by the decline of collective bargaining. So briefly on each axis here. So focusing first, the first question is, why emphasize regulatory versus bargaining solutions to the problems faced by low-wage workers? And again, I don't in any way want to undercut the possibilities and would hope to bolster the possibilities for organizing and collective bargaining. But the short answer to this emphasis on regulatory approaches is that workers have been losing bargaining power, not just through the decline of collective bargaining, but because of other trends in the economy that undercut workers' individual market power. And that I focus especially on those trends that render workers more easily replaced, more easily replaceable. So workers now, including some low-wage workers, are enjoying a kind of modest rebound in their market power, but economists tell us that we're likely to see a resumption of the downward trend in labor's share of income and growing inequality. Those trends are likely to dominate in the long run. So since the 1970s, major firms have been systematically shedding workers. We're quite familiar with this. Workers and labor functions through fissuring techniques, which include everything from domestic outsourcing to overseas suppliers, but also the splintering of jobs into gigs and domestic outsourcing. Some of these purport to put workers outside of the employment relationship, others put them outside of the jurisdiction. Often allows employers to escape the burdens of employer status and the corresponding, and to vitiate the corresponding employee rights and protections. So in any case, however it takes place, fissuring generally leaves workers worse off, with lower wages and benefits and fewer paths to advancement than their predecessors used to enjoy inside big vertically integrated lead firms. Sort of alongside those trends, we've seen automation, which has been ongoing for decades. So many workers, especially in manufacturing, have been displaced by machines. The potential for net job destruction from automation is often overhyped, admittedly, and it's hotly debated right now among economists and technology experts. But there's reasons to believe that, that this time might be different because of the versatility and potency of artificial intelligence and some new innovations in AI. Automation, in any event, is already, oops, I forgot to go to my next slide again, is already exacerbating economic inequality by destroying more decent middle-class jobs than it's creating. So automation and fissuring are all ways of replacing employees with either machines or with other workers who are in a weaker market position, whether because they're isolated in lower profit, lower wage sectors of the economy, like say, maintenance sector, or because they're located in poorer, less regulated jurisdictions, in the case of outsourcing, offshoring, or because of their legal status within the jurisdiction, as in the case of independent contractors. So these employee replacement strategies tend to undercut workers' bargaining power, even if they're not exercised. So the idea here, a firm's realistic option to replace a given group of employees, whether it's by contracting out their jobs or replacing them with machines, that dampens employees' bargaining power, even if that remains just an option. And the impact of these developments obviously is felt most heavily by workers without higher education or advanced skills. Technology plays a role in all of these options, not just automation, but fissuring by lowering the costs, economists will call them transaction costs, that are associated with explicit contracting for outsourcing, for example. So technology has helped to expand firms' outside options and to make it easier for employers to get what they want without directly employing people. So one investment banker put it, he said, CEOs these days ask, quote, can I automate it? Can I outsource it? Can I give it to an independent contractor? And this is still the quote, hiring an employee is the last resort. So the growing menu of alternatives to employing workers depresses the labor market power of workers for whom fissuring or automation affords a possible substitute. So the NLRA was designed to fortify workers' bargaining power by enabling them to aggregate that bargaining power. But my concern is that even if we reform labor law to make that possible, so that workers actually do have a fair opportunity to collectivize their market power, they just don't have enough of it. They don't have enough of it to make up the ground that they've lost in our globalized, fissured, and increasingly automated economy. So beyond reforming labor law to make unions and collective bargaining feasible, we also need other strategies for improving wages and working conditions of workers without specialized skills and higher education. Strategies that depend less on aggregating workers' power and more on supplementing that power. So one other virtue of shifting from a bargaining frame to a regulatory frame will be very familiar with the labor lawyers in the room, and that's federal labor law preemption. There's a lot more political latitude for pro-worker lawmaking at the state and local level in blue cities, blue states, than at the national level. We know that federal labor law preempts state and local efforts to regulate and improve the prospects for unionization and collective bargaining, and would presumably preempt any state or local effort to institute sectoral bargaining. But it doesn't preempt states and cities from enacting higher substantive labor standards. Okay, so still on the horizontal axis, what do I mean by co-regulation, and how is it different from conventional regulation? By co-regulation, I simply mean structures in which the worker beneficiaries of the regulation of the scheme play an institutionalized, ongoing role. The idea of co-regulation is to infuse regulation with some of the virtues of collective bargaining. So workers know and care a lot about their own wages, safety, hours, schedules, other terms and conditions of employment. So we could clearly improve our ongoing efforts to enforce labor standards by bringing all that knowledge and all that motivation into the enforcement process and into the structures of corporate compliance that firms have instituted under the shadow of all the regulations that we have in this area. That requires some kind of institutionalized collective representation of workers, and if that isn't happening through enterprise-level unionization and collective bargaining, we need to find other ways of getting workers represented in that process. But I want to, this paper is more about standard setting itself, and I want to argue that standard setting itself could improve if we were to incorporate workers' voices and knowledge and voices, their choices in the regulatory process through representative organizations. So labor standards could be more responsive. The system as a whole could be more democratic if workers were able to participate in the process. And I mean the process of standard setting, ongoing monitoring of, do the standards need changing, but also in ongoing monitoring of compliance and assisting in enforcement. Now, that's all stuff that workers can do through collective bargaining under our existing system. It's just that workers have to run this gauntlet of union organizing, which few workers manage to do. So I'm looking for additional ways that workers can participate in that standard setting and enforcement process. And the other problem with collective bargaining is that it still turns on workers' bargaining power. So the point is, workers need more of a voice than they currently have in conventional regulatory modes of formulating and enforcing labor standards. And they need more leverage than they have within a collective bargaining system, dysfunctional as it is. They need the power of the state to support and improve labor standards. So that was the original mission of the FLSA, the system of minimum standards, to protect workers who didn't have enough market power to protect themselves through collective self-help. The idea of the hybrid or tripartite co-regulatory institutions like the New York and California standard setting structures is to combine some of the virtues and combat some of the shortcomings of both of those dominant strategies for improving terms and conditions of work. So I can be much quicker on the vertical axis because I think the argument for sectoral standards versus either enterprise level standards or jurisdiction-wide standards is a bit more straightforward. Sectoral labor standards can take basic economic terms out of competition within a sector and can force all firms, including new entrants, to meet those basic standards and compete on grounds other than by undercutting labor standards. Productivity, quality, innovation, all available modes of competition. The idea is to take labor cost competition, downward pressure on labor costs out of that formula. So this is a major factor. Sectoral bargaining is a major factor in the stronger unions and lower levels of economic inequality that prevail in most European countries. So compared to jurisdiction-wide standards, sectoral standards can obviously be higher, and they can also be more specific or more customized to the problems that exist in a particular sector. They can overcome what I call the least common denominator problem. The advantages of sectoral bargaining were not lost on US labor leaders. They aspired in the New Deal to achieve sectoral coverage through individual enterprise level organizing and then pattern bargaining across a sector. And that was largely achieved in auto, steel, some other major industrial sectors for a while. But enterprise-based organizing and bargaining was always a pretty precarious platform for that, and that platform pretty much collapsed. So the fate, those rich quasi-sectoral deals were a bit too rich, as it turned out, in a more competitive global economy. And that teaches some lessons about sectoral standards. They have to be, in order to be sustainable, they have to take into account the conditions faced within the sector, both what's your product market in which you compete, productivity levels, exposure to competition from outside, whatever jurisdiction is setting the standards. But this points to another virtue of sectoral standards. As opposed to jurisdiction-wide standards, they can take into account sector-specific considerations like productivity, scope of competition, level of concentration. And sectoral standards can also deal with very specific, sector-specific problems like just-in-time scheduling practices that are the bane of many retail workers' existence. They're very common in food and retail. And they have triggered some sector-wide regulatory responses at the state and local level, some of them with some co-regulatory elements. Or to take a recent example in New York City, access to bathrooms in restaurants that are served by delivery workers. That is not a problem that is going to rise to the level of a jurisdiction-wide standard, but that was one of the major issues dealt with by New York City legislation on the food delivery worker sector. So sectoral standards can be more customized than across-the-board minimum standards, and they are less vulnerable to the low-road competition that plagues enterprise-based standards. New entrants into and I say that because new entrants as well as existing actors have to meet the same sectoral standards. So when I first sketched these ideas in a lecture over a year ago, the New York Wage Board was really the main example. Only cognoscenti would even have known of that, but that was pretty much the main example of what I call sectoral co-regulation on the ground. It was a little bit exotic, a little unusual. Did it have legs? Who knew? Since then, the California FAST Act has raised the profile of this form of regulation, of standard setting, but there have been a lot more examples in the last couple of years. The wage board model in New York has been applied in agriculture and salon nail workers. Tripartite boards have been a particularly popular innovation in dealing with care workers and domestic workers, so nursing home workers. Last week, Minnesota, for example, adopted a tripartite board structure for regulation of nursing home work. The potential scope for sectoral co-regulation is vast, given if you actually focus on this question, you find out that sectoral regulation is, it's been there from the beginning. Take the New York scaffolding law, a sector-specific labor protection law to protect construction workers from the 19th century. But take the mine workers, the Mine Safety and Health Act at the national level, and if you get down below the level of the legislation itself, OSHA standards themselves are often sector-specific. Those are all laws that in many cases could be improved and made better adapted to workers' changing circumstances if they incorporated co-regulatory elements, representation by workers. So there are significant challenges and questions, including some governance issues, rule of law issues. I do delve into the paper a little bit on those issues. But my main aim here is just to sort of open up this middle space to more rigorous analysis and to stimulate creative thinking about the future of work and its governance in a way that's both complementary and supplementary to our existing standard across-the-board minimum standard strategies and our enterprise-based collective bargaining strategies. So I look forward to the comments and to your comments and questions after that.
So I started as a corporate lawyer, but Tuesday, the day after Memorial Day, will be 20 years as a union side labor lawyer. It was a good choice. I find the work very meaningful, work with some of my closest friends. And I have to admit, I met some very fine people on the other side of the bargaining table. One thing I learned over the last 20 years is that all efforts to better the lives of workers are at best short-lived if the workers themselves do not participate. So Professor Estlund's idea of a sectoral co-regulation, while fantastic, I believe is only sustainable if, as a result, it emboldens workers to join the labor movement. Just want to share a quick story. About 10 years ago, this is in Brooklyn, a community organization group approached one of my union clients and asked for funding, asked for help. It offered 100, 200 workers who were ready to sign up to the union. They had built a rapport with this group for years and just wanted funding to get past the finish line. And this might actually be the worst reference by a union side labor lawyer, but remember The Godfather when Salazzo approaches Marlon Brando, offers him 30% of the drug business, and Marlon Brando says, why me? What have I done to deserve this generosity? Right? So, of course, my union client asks this community organizer the same thing. They're handing them 200 workers. And you remember Salazzo's response? If $1 million is for you a mere finance, salute, Don Goleon. I mean, that's a lot of money, but this is about $1 million easy to engage in these efforts to organize workers, to raise their wages like 25 cents or give them that extra day. I mean, it is a lot of money. You're talking about lawyer fees, hotel room fees, picket signs, publicity, the whole bit, It is a lot of money. And in history, there is no other organization but the union that provides that kind of funding. You have the Ford Foundation, some tax write-off, but it is the union labor organizations that fund these movements. But unions have a dilemma here. I mean, unions make their money from union dues. Hardworking individuals who are paying monthly dues. And what do you do with that money? How do you use that money to better the lives of people who are not willing to pay that money or have not contributed any? So it's a hard thing to do. So what happened here was the union, the campaign was so successful. I mean, all of these workers got hundreds of thousands of dollars back in back pay, overtime, safety violations were all corrected, OSHA violations, everything. And in time, 5 of the supermarkets, so this is a set of supermarket workers, immigrant supermarket workers in Brooklyn, a specific sector. And 5 of the supermarkets were organized eventually through the long process of the NLRB. They have 5 contracts, great contracts, upping the wages from what was effectively $4 to $12, whatever it was. I mean, if you look at the contract, it looked very great. So it seemed like a great success. But one of the great musicals that are on right now is Into the Woods. I don't know if you guys ever seen it, but it's one of my favorite musicals. The best part of it is the first part. There are 2 parts. First part is you have the story of Little Red Riding Hood, Jack and the Beanstalk, and you're culminating in this conflict, and everyone gets a resolution. At the end of the first act, everyone's happy. And then you go to intermission, and then you come back, and then you hear the rest of the story. I mean, there's infidelity. I mean, half the cast dies. People are crushed by giants. And that's what happens here. Because the fervor died away. People got their lump sum back pay. People realized, wait, I got to pay union dues monthly? I never used to pay this before. I got to get paid in little paychecks with taxes taken out. I can't work 70, 80 hours anymore. By mid-first contract, shockingly, 80% of those original individuals disappeared somewhere, replaced by other workers who are, I mean, you go to Brooklyn, you'll see these supermarkets, they're all fixed up. They look great for us consumers, in suits. It looks nice. No violations, no rats running, but wow, it disappeared real fast. So what do you think happened to the relationship between the union and the community organization? There was none. How about the stories of these immigrant supermarket workers who need help? This is a disaster. So But don't get me wrong, it was a success. For that moment, a lot of these workers, for the first time, had a voice, somebody to listen to them, and they were able to speak out against all these things. So for that moment, it was fantastic. It was short-lived because there was no participation. Sectoral core regulation is not a new idea. The FLSA, when it was enacted and passed 1938, they actually had an FLSA wage board. It was called the Industry Committee. So the idea was a tripartite organization represented by union representatives, representing the workers, notably not a single non-union worker representative, but anyway, union representative, employer representatives, and government. So what they did was, when the law passed, the minimum wage was raised to 25 cents with the goal of, in 1945, 7 years later, automatically becoming 40 cents across the board. So these committees were formed. In 1939, there were 7 committees that were formed. The usual, the textile, apparel, millineries, the fancy woman's hat. And a year later, 1940, 20 committees were formed. And then 41, a total of 70 committees. And what they did was they had multiple hearings back and forth. And you know who supported that? The union, the AFL, the CIO, putting tons of money. And during that process, also fighting off legal challenges, multiple legal challenges, and fighting off a lot of hostile employers, especially from the South. I mean, they spent tons of money doing that. Now, the question is, all right, so what happened? What happened? In 1944, the 70 committee members decided, hey, you know what? We recommend 40 cents in 1944, a year before it was supposed to automatically kick in. Was that a great success? Was that great success? To have to spend all that time to just get the 40 cents enacted a year earlier? I don't know. It was very costly. Unions spent a lot of money. How did it convince workers to join the union? Because sure enough, at that time, you had a huge surge in union membership. And that was based on a lot of factors. You had the post-depression sentiments, pro-worker sentiments. But if some other committee is negotiating your wages, why do you need a union? Why do you need to pay dues? So what the unions did at that time was a vehicle for the enforcement of the FLSA violations. So the AFL and the CIO all formed little wage and hour committees where they would help everyone, and that worked. About 4 out of 5 complaints that were filed were successful if filed with the help of one of these unions. And conversely, 1 of 5 just failed as lacking evidence and whatnot. So through that mechanism where you get this immediate chunk of money, union membership surged. But that was really it. There was an article, The Hat Workers, which is just a journal. It said the Lawrence Hat Company case illustrates the vital functions the union perform in the enforcement of the wage and hour law. I mean, that was published because in that one case, the Lawrence Hat Company case, they were able to recoup $6,000 for the workers. And I did the math through Google. It's about $140,000 in today's money. So it was successful at that time. But then Into the Woods Part 2 kicks in, right? So what happens to the membership since then? I mean, right now it's at 6% for private employees. There's a reason for it. You put everything on that state regulation of 40 cents, then what good is the union? But there are many other factors. Legislators, pro-management legislators were elected, passed Taft-Hartley, made limitations on the wage and hour, like statute of limitations and things of that nature. So, this law that was, the golden goose was no longer the golden goose. And what is the use of unions? Right? So again, without participation, without workers saying, hey, I'm in it for the short run, I'm in it for the long run, it's bound to fail. And that brings us to the California, New York laws. I mean, amazing efforts by these unions to kind of think out of the box. They can't organize these workers. What do we do? So, they joined with they passed these laws, trying to kind of go around their inability to organize, set certain standards. SEIU, UFCW spending, tens of millions of dollars every month at times? Final to total. I mean, this is union dues from, doormen, just workers, and using that money to benefit who? Pretty much everyone in New York City. I mean, Fight for 15, everyone benefited. Every, blue-collar worker, every McDonald's worker benefited, right? Did they even thank the SEIU? Did they say, hey, thanks, guys, or thank the workers who donated to this? No. There was a sense of almost entitlement. It's like, hey, it's wrong that Bezos is making this much. I should make. No, that's not the way you should be thinking. Without participation for the employees, and here I'm talking, donations or dues. It's short-lived. I feel, SEIU and other unions were able to pass a deductions law where it's like a New York City little ordinance or statute, whatever it might be, where if you say to your employer after you get a certain amount of signatures, hey, you know what, I want to voluntarily donate from my paycheck to this not-for-profit group, then the employer has to do so. I think at inception in 2018, there were 1,200 participants, pledges to pay $13.50 per month to this not-for-profit organization formed by the SEIU, I think Food for Justice. Yeah, how much does that come out to at the end of the year, even if all of those guys actually pay? $16,000? It's nothing. So again, my fear is that, fine, these great ideas are happening in California, New York, but what's going to be part two of Into the Woods? I mean, right now, this is so exciting. You read the newspaper. I know there's some journalists here. It's like, oh wow, the labor movement is fantastic, but I fear what's going to happen. Just a real quick thing, last two notes. The reason why it works in certain European countries, sectoral core regulation and bargaining, like for example, the Nordic countries. I mean, Iceland has what, 90% union membership? Scandinavian countries up to 70%. Just last month, 24,000 people in Norway walked out for 4 days, and they got their 5% across the board. It works only if you have that base, which we did have right after, Depression, and we don't have that. So, things need to be reconsidered. The strongest, I believe, as 20 years of working as a union, just on the streets and in the courts, you got to get workers involved. Any other paternalistic method of trying to do good, it's not going to work in the long run. Thank you.
So, we've been talking in a very ethereal sense. I want to talk about a couple of things that are really quite concrete. First of all, I'm happy to comment on Professor Eslin's paper, which is, as are all of your papers, elegantly written and very interesting. I disagree with your conclusions, and here's why. Let me start with two points. I'm not talking about worker involvement in standard setting or in the Fight for 15. I'm talking about whether or not state or local government should be regulating the private sector workspace. I think that is a huge problem. I think it's wrong. I think it's contrary to the National Labor Relations Act, and I think it's just a bad idea. Let me talk first about labor preemption. I know you guys would like to hear my standard lecture on labor preemption. Sam has heard it from the times that we've co-taught it, and everybody's head hits the table, so we'll skip the injuries. But look, let's talk about what Congress actually did in terms of the labor laws. It balanced employee rights, union rights, employer rights to create a system of industrial self-governance where the parties could agree and could revise their bargains based upon what they thought was best in the workplace. Enterprise bargaining, yes, absolutely. Cooperative management, sometimes not. But it's based upon freedom of contract and altering the bargain when it makes sense. Supreme Court case after Supreme Court case reinforces this and says that state and local government should not be regulating the private sector workspace. They just should not. Now, there's a piece in the materials you have about the New York City fast food ordinance by Professor S. Stryker and by me. Here's what that fast food ordinance says, and you tell me if this is consistent with freedom of contract and the parties regulating their own workspace. And bear in mind that these are mandatory standards in all fast food restaurants within New York. There's a 30-day maximum probationary period. Employees beyond their probationary period may be discharged only for just cause or, quote, a bona fide economic reason, which the law defines as, quote, the full or partial closing of operations or technological. It goes on for a while, but it's quite specific, okay? Just cause requires progressive discipline, which means a graduated series of penalties for minor offenses unless the employee's offense is egregious. What's that mean? Never defined. The employer must provide the employee within 5 days of the termination a written explanation for, quote, the precise reason for the termination, and may never alter or amplify its explanation. If the termination is challenged, the employer must establish that its rules were known to the employee, that the employee was adequately trained, that the disciplinary policy was reasonable and consistently applied, and that the employer undertook a fair and reasonable investigation of the matter. And finally, employees who claim that there was a violation of any of these standards are allowed to opt for arbitration, even though the employer has never agreed to arbitration, and may bring their arbitration case as a class action. The arbitrator has the power to assess compensatory and punitive damages, attorney's fees, fines, you name it, okay? Now, those are mandatory standards. That is the New York City City Council decreeing these are mandatory standards for every fast food restaurant that's covered by this law, and they can't be varied, they can't be modified, and that's the end of the game. I don't know how you square things like that with freedom of contract and collective bargaining at all. It's even more clear to me that this is, you can't, in these circumstances, require non-consensual arbitration and class arbitration, which the Supreme Court's made very clear is the product of consent and not forced labor. I think these are all inconsistent with basic premises of the National Labor Relations Act. This is being litigated. There is a district court decision by Judge Denise Cote, who is a terrific judge, very smart, who I think got it wrong. She, you know, I'm not practicing anymore. I'm not going to appear before her again. And it was a pleasure to appear before her every time I did. She's the terrific. I know she was your classmate. We've talked about this. She's a great judge. But here's what she ruled. She said, look, these standards are fine, and the only area for labor preemption is if you try to change the bargaining process itself. That is, state and local governments can decree whatever labor standards they want in any circumstances for every industry. They can get involved in all of this kind of stuff. Just don't say that some strikes are legal and other strikes are not legal. Don't mess with the bargaining process. Yeah, okay, I can finish by that. You know, but why do we have this regulation, the bargaining process in the first place? Who cares if they're sit-down strikes or quickie strikes, the things we were talking about before? What for? And that's to allow the parties to create their own bargaining system. It's a balance, right? I mean, we all learned this when we learned labor law. You have a balance, and the parties work out their own deal. They change their own deal if they want to change their own deal. That is the deal. And the government of the City Council of New York shouldn't be involved in this. The state of Minnesota shouldn't be involved in this. That's the whole purport of labor preemption cases. So I don't think this is a particularly difficult question. Having said that, okay, let's not talk about labor preemption. Let's talk about policy issues. I agree, low-wage workers are a particular problem in this industry, in any industry. I don't share the view that unscrupulous employers who take advantage of low-wage workers should be spared the penalty of the law. They should be prosecuted. They should be dealt with. But I don't agree that state and local government should be running the show. You know, they've never shown themselves to be wise stewards of labor relations. I was in Chicago a couple of years ago, and I listened to an actual Illinois state legislator who was talking about unfunded pension liabilities, which were going to drive the state out of business. And he actually proposed to split the state of Illinois, give part of it to Iowa, part of it to Wisconsin. I don't remember what he wanted to do with Chicago, which is, as you can hear from my accent, where I was raised. But, you know, I mean, they don't know what they're doing. I mean, they just don't. And on the occasions when the government gets involved in standard setting, look at what happened in the railroad industry in 2022. The federal government used its powers under the Railway Labor Act and imposed an agreement upon the whole industry, right? That agreement was widely criticized by organized labor because organized labor wanted 15 paid workdays. And the government said, you get one. Organized labor went nuts, but that was the agreement that was reached. So every time you talk about state and local governments getting involved in regulating the workplace, it's good and it's bad. Now, is collective bargaining broken? I don't think so, but, you know, the primary evidence of it being broken apparently is the low union density that we have, right? 7%, less than 7%. Well, I think that may be changing. And let me give you a couple of numbers. In 2022, the NLRB held 1,249 representation elections. Unions won 72% of them. 200,000 employees were added to union roles. Polling shows that unions now receive a favorable rating from 71% of the public, which is the highest number since 2015. 230 Starbucks have been organized in the last few years, even some Amazon warehouses, despite Nomadland, which is a great movie. But despite Nomadland, you have Amazon warehouses being organized, hundreds of grad student teaching assistants have been organized. So I'm not sure that we're done with collective bargaining. If there are problems in the system, and I agree that there are problems in the system, let's fix those problems. Professor Estreicher yesterday outlined some of them. I agree with him on almost all of those. 10J relief ought to be sought more frequently. Gissel orders ought to be sought more frequently. I have no problem with banning 24 hours, take a day of rest, stop all the campaigning before a union election. Those are the types of things that I think we ought to be concentrating on, and we shouldn't be turning over private sector workplaces to the city council of the city of New York, or to state governments like in the state of California. I think that's a big mistake. So that's my thoughts.
Is there any time for
You have 2 minutes for questions.
for questions from here?
Yeah.
Okay.
We'll stick behind. All right. My name's Terry McGinnis. I'm an SEIU lawyer. I represented 32BJ for many years. And I want to stand up a little bit for the SEIU and 32BJ. 32BJ members donated their money to those campaigns because the mantra of that union was, you're going to die unless you spread your standards to other sectors of the workforce. It was that simple, and most of the 180,000 of them now started, just 100,000 of them just 10 years ago, will tell you that that's exactly what they do. And the SEIU did pour millions and millions and millions of dollars into organizing fast food workers, precisely because fast food workers are almost impossible to organize because the law is broken, the collective bargaining law is broken, and they used all of the resources that were available to them, including our democratically elected city council, our democratically elected state legislatures, to do different kinds of things to grow and essentially foster organizing opportunities of fast food workers. And, you know, the Fight for 15 was an incredibly big project of the SEIU, and there is no coincidence in the fact that the wage board that was done in New York in 2000 and whatever the hell it was,
15.
came up with a minimum wage that was $15 an hour. It was the apotheosis of that campaign in a lot of sense. And so I think unions have to use these various leverages to organize very difficult industries. The fast food industry is fissured through the franchise process. And you can't just organize 200 Starbucks individual units and think you're going to be able to make a dent in what those Starbucks workers are going to be able to do nationally. And that's why sectoral bargaining makes sense. The question I have is, it is a question, I'm sorry. is, you know, it's true that the workers' gains in the enterprise system depend on, you know, in the bargaining system, depend on their success and continued success in that enterprise system. But the co-regulatory system that I like depends on unions politically. And just as Jay was saying, you know, it's no coincidence that in California and New York and Minnesota, you see that the unions where they have had huge political power have succeeded in getting co-regulatory schemes somewhat succeeded. And so my question to you is the ultimate question, which I think you alluded to, but said that's the next paper, which is where does that political power come from if union density evaporates and you don't have this political power? I mean, because ultimately Jay is right, there has to be a base. Mario Cuomo didn't do the wage board because he liked workers. It's no coincidence that the labor member of that labor board was the secretary treasurer of the SEIU. And that was the political power that came from the treasuries and the people in the street that those unions had based entirely on enterprise bargaining.
Very simple question.
Yeah, very simple question. So I thank you so much. Oh, okay. Oh, okay. So I agree. If there is no complementarity between standard setting in this alternative way and organizing, that's trouble. That is absolutely trouble because yes, workers need, but there are, you can form alliances. The fact that the food delivery workers managed to put together a coalition for lawmaking on some very specific issues is encouraging in some ways.
Can I add one footnote to this? Just one. Which 15 seconds. Terry, overlay the map of union density and the red, blue, and purple states, and you'll see the problem. It's a bigger problem than what we're talking about here. But the red, blue, and purple states overlaying union density, this is a national problem, and it goes way beyond what we're discussing. That's why it's the next paper.